A bounced check, you might think it's just a headache, right? A frustrating delay. Well, in India, it's a whole different ballgame. It can actually be a criminal offense with some pretty serious consequences. So if you're in business, listen up. Understanding the law here isn't just good practice, it's absolutely essential to protect yourself and your company. All right, let's get right into it.
So, what you see here, this is basically the blueprint for a massive shift in Indian commercial law. See, it wasn't always this way. Before 1989, if a check bounced, it was just a civil matter. The big problem, trying to get your money back through the civil courts was, well, it was a nightmare. It was slow, agonizingly slow, and that really started to erode trust in day-to-day business. It was clear that something had to give.
And oh boy, did it change. This one piece of legislation, the Banking, Public Financial Institutions, and Negotiable Instruments Laws Amendment Act of 1988, it completely flipped the script. As of March 31st, 1989, we went from that sluggish civil liability system to something much, much faster and way more severe, criminal liability. I mean, this single move gave the law some serious teeth and completely changed the game for business accountability. Okay, so here's what we're going to cover today. We'll look at why a bounce check became a crime. Then we'll decode the key law, Section 138. After that, we'll dive into the corporate minefield. Who's responsible when a company's check bounces? We'll also walk through the legal logic and procedure and wrap up with some practical advice on staying compliant. Let's jump in. All right, Section 1, a promise, now a crime. So you might be asking, why go so far as to make this a criminal issue? I mean, really? Well, the goal wasn't just about punishment. It was actually a much bigger strategic play to strengthen the entire financial system. And this quote right here from a landmark case really gets to the heart of it. The whole point of Section 138 is to inculcate faith in the efficiency of banking functions. You know, in plain English, it's about making sure that when you accept a check, you can trust it. The idea was to make a check as good as cash, so the wheels of business can keep turning without a hitch. Okay, let's get into the nitty-gritty. What are the actual ingredients that turn a simple bounce check into a criminal offense? Well, that's all spelled out for us in Section 138.
So for this to be a crime, 4 key things have to happen. It's like a checklist. 1, the check has to be for a real debt or liability. 2, it has to actually be presented to the bank. 3, a no-brainer, it gets returned unpaid. And 4, and this is important, the reason has to be either insufficient funds or it exceeds the arrangement you have with the bank. If you tick all 4 of those boxes, boom, you've got a criminal offense.
And the consequences? They are not kidding around. We're talking about potential jail time up to 2 years. And just to give you some perspective, this was actually doubled from 1 year back in 2002. So yeah, the law has only gotten tougher. But wait, there's more. On top of potential prison time, the court can hit you with a fine of up to twice the amount of the check. And yep, they can absolutely do both, jail time and the fine. That's a massive financial hit designed to make you think twice. Now, for any of this to stick, the procedure is absolutely critical. There's a strict timeline. First, the check has to be presented within 6 months. Once it bounces, a 30-day clock starts for the person holding the check to send a written demand for the money. The person who wrote the check then gets a final chance, a 15-day window to pay up. Only if they still don't pay after that notice can a criminal complaint actually be filed. You have to follow these steps to the letter. Okay, so what happens when it's not an individual, but a company check that bounces? This is where things get really tricky. Who's actually responsible? Section 141 tackles this head-on, and believe me, it's a real minefield for anyone in management. The law starts with a pretty stark assumption. By default, any person who was in charge of and responsible for the company's business is considered guilty. That's right, deemed guilty right off the bat. If you're a director or a manager, you really need to let that sink in. But there is an escape hatch, and this is your only defense. You can get off the hook, but only if you can prove 2 things. First, that the whole thing happened without your knowledge. And second, that you did everything you possibly could, exercised all due diligence to stop it from happening. The key word there is proof. The burden is 100% on you. And the liability doesn't stop there. The net can be cast even wider. If it turns out the offense happened with the consent or connivance, basically if they knew about it or helped it happen, of any director, manager, secretary, or other officer, well, they're on the hook too. They get pulled in and are considered just as guilty. All right, so we've talked about what the crime is and who can be held responsible. Now let's get into the how, the actual legal process, from filing a complaint all the way to court.
Okay, this is a real game changer, especially for the person who received the bad check. It's called the presumption of debt under Section 139. What it means is the court automatically assumes the check was for a legitimate debt. So the person who got the bounced check doesn't have to prove the debt was real. Instead, the person who wrote the check has the uphill battle of proving it wasn't. That is a massive advantage in court.
So here's the roadmap to prosecution. The check bounces, you send the demand notice, the 15-day payment window slams shut. From that moment, you have exactly 1 month, 30 days, to file your complaint in court. Again, these timelines are rigid. You miss a deadline, and your case could be dead in the water.
And you don't just file this complaint in any old court. Section 142 is very specific. These cases are taken up by a metropolitan or judicial magistrate. This ensures they're handled by a judge with the right level of authority.
All right, let's bring this all home. For anyone in business, this is probably the most important part. How do you actually avoid all this trouble? Let's talk practical advice for staying compliant. So, the absolute first thing you have to get your head around is that this is a strict liability offense. Section 140 makes this crystal clear. It doesn't matter if you genuinely thought the money was there. Your intention, what lawyers call mens rea or a guilty mind, is irrelevant. The simple fact that the check bounced is enough. Saying, oops, I made a mistake is not a defense here. So, remember that due diligence defense we talked about? How do you actually prove it? Well, this checklist is your game plan. You need solid internal systems. That means keeping meticulous records of every check, always ensuring funds are there before signing, maybe implementing a 2-signature rule for big payments. You need to have crystal clear lines of authority. And crucially, you have to train your people. Everyone involved in finance has to know what's at stake with Section 138. And that really brings us to the final and maybe most important question. I want you to think about your own company, your financial processes. Are they just something you do out of habit, or are they a truly robust system designed to prevent these mistakes? Because when you're standing in front of a magistrate, that distinction is everything. It could literally be the difference between a simple, manageable error and a criminal conviction.